participants do we have today so far?
A very good afternoon, ladies and gentlemen. Thank you for tuning in. I hope you're having a pleasant day. It's great to be back again this week with another episode of the Strata Talk Show. With that, I would like to welcome everyone to the 65th episode of the Strata Talk Show, brought to you by the Excel Academy of Real Estate. To our new viewers, in this talk show, we'll be discussing issues and cases related to the management of stratified developments with various industry professionals. And joining us today, we have Mr. Patrick S. Sebastian, who is an advocate and solicitor of the High Court of Malaya, to speak on the topic of determining common property in stratified developments. If you have any questions for Mr. Patrick, feel free to leave them in the Facebook comment section below, which we will address in the Q&A section at the end of the show. Without further ado, join me in welcoming Mr. Patrick S. Sebastian. Welcome, Mr. Patrick.
Yes, thank you very much, Afal. Right, a very good afternoon to all of you, those who are participating here. And it's very interesting to join in this talk as more and more people are beginning to either live in stratified properties or even working in stratified properties. So we have, according to the latest estimates, the figures that are given to us, roughly there are some 8 million people living in stratified properties, either as owners or as tenants or as lessees. And also there are plenty of office blocks. Even my own office block is a stratified development. And so all owners and tenants and residents will face challenges in these stratified properties. I try to pick out those topics which are most pertinent, especially when it comes to going to court and litigation and the complaints that I hear very commonly. And the last time I spoke to you all also a little bit about the maintenance fund and the sinking fund account. This is one area of complaint. Another area of complaint, of course, is regarding the common property. Now, I know some of us are getting rather tired about this issue, but this is a very live issue and it keeps coming to us again and again and again. Somehow, one way or another, the issue of common property keeps creeping up. And we need to ask first and foremost, why are we having so many issues regarding common property? Now, the first and foremost reason is common property being a very live issue, challenges develop over a period of time. And therefore, the law is constantly playing a catching up game, trying to catch up with this common property. And as the law develops, things keep changing every now and then. So when we look at a particular development, for example, the first question that must come to your mind when you think of common property is, when was this project completed? Was it one of those very old projects which were completed even before the Strata Titles Act 1985 came into effect? These are the old flats, the old low-cost houses, areas like formerly in Pekeliling, the Pekeliling flats, which have now been demolished to make way for all those MRTs, the Sunping flats, the Jalan Tun Razak flats, in Cheras, you have all those Sri Sabha flats. Those are all the old flats which have existed pre-1985. And so you find that you want to find the word common property Even the word common property cannot be found simply because those were all governed under the national land code as subsidiary titles. Then comes the Strata Titles Act 1985, which gives us a very, very simplified version of what is common property. Section 4 of the Strata Titles Act, the original Strata Titles Act, just says that a common property means that which is not the parcel and that which is not the accessory parcel. So, very simple. You want to determine what is common property? Exclude all the parcels, exclude all the accessory parcels, and whatever remains becomes your common property. Now, this was one of the methods used in the courts in one of the cases where the judge said, as far as I know, in a stratified development, there are only three types of property: the parcel, the accessory parcels, and the common property. There is no other forms of property known to the law. This was very true at the time. So, having this in mind, you must look at your development. If your development is post 1985, but pre 2007, 2007 being the year the Building and Common Property Maintenance and Management Act came into effect. Now, if yours is post 1985, pre 2007, then you will have to do this. You will have to look at your sale and purchase agreement. And from your sale and purchase agreement, you have to determine what is your parcel, what is the accessory parcel, and that's it. The rest becomes common property. This was the decision taken in several cases over properties which were developed in that interim period. Okay? So we have the case of Badan Pengurus Sama, Paradesa Rustika, and Sri Damansara Sendirian Berhad in 2014, which, although decided after the Building and Common Property Act came in, it was on a building which was completed, of which vacant possession was given prior to this BCPA. So, since the vacant possession was given prior to the BCPA, therefore, only the Strata Titles Act apply. And the federal court in Malaysia said two things. Number one, it said the BCPA does not have retrospective effect, and therefore it cannot be used to backdate something which did not exist before. Number two, it says that the common property, according to the Strata Titles Act, will have to be determined by the sale and purchase agreement entered into between the parties. So the second statement, of course, was in passing because, in actual fact, the case was more about a maintenance fund, right? Maintenance fund. However, the principle is the BCPA does not have retrospective effect. So we go back to the Strata Titles Act, which tells us straightforward, common property is something which is not parcel, which is not accessory parcel. Right. Now, following this case, the Court of Appeal in another case, and that is Prantara Property Center in Berhad and JMC Klana Square and another in 2016, applied the federal court decision and said, yes, the BCPA does not have retrospective effect. In this case, JMC Klana Square, the issue was whether there was a food court, there was a deli, there were some car parks, whether all these were actually common property or not. And the Court of Appeal said, since the BCPA does not apply, we go back to the STA. The STA merely states that common property is not parcel or accessory parcel. Therefore, we have to fall back on the SPA. In the SPA, it was expressly stated that The deli, the food court, and the car parks do not form part of the common property. And because it was specifically stated as such, it means that the developer has retained ownership of those properties. And like any other owner, he will have to pay a maintenance fund and contribute to the sinking fund. But he is the owner, he remains the owner. So this was a very troubling decision, of course, for many people. And if you ask me why, I will tell you this. You can have a title to your parcel. Your accessory, of course, becomes part of your parcel. It is attached to your parcel. The rest is common property. There is no such thing, or at that time, there was no such thing as a car park parcel. Such a parcel did not exist. So how could the courts have actually said uh, the car park you can retain? You're retaining the car park as what? Now, if the car park was retained as part of a parcel, means the car park is being retained as an accessory, then that is a different question altogether, right? However, if it is not, then that becomes a problem. So this became an issue, and many of the developers took advantage of this case, took advantage of the decisions of the court that the BCPA does not have retrospective effect, right? I'm very sorry here. There's some work going on upstairs, so you might hear some banging sounds. Okay? So the developers took advantage of it, and unfortunately, that is the law. So even when they come to me for advice, I will tell them, well, you are entitled to it. And so the owners and the JMC or the MCs are very, very unhappy about such a development. But that was the law. That was the law. There's nothing we can do about it today, right? Then comes the next stage of the BCPA 2007, which gives a certain definition, a very inclusive definition of what is an accessory or a common property. Sorry, what is common property? So there was some guideline given by the BCPA, which is the first law to say this. Now, let me read to you what the BCPA actually said. Come in section 2. Common property in relation to a development area means so much of the development area as is not comprised in any parcel. So to that extent, it's the same as the STA. But it goes on to say, such as the structural elements of the building, stairs, stairways, fire escapes, entrances and exits, corridors, lobbies, fixtures and fittings, lifts, refuse chutes, refuse bins, compounds, drains, water tanks, sewers, pipes, wires, cable, and ducts that serve more than one parcel. So if there's any of these things, like say a corridor, which serves more than one parcel, it becomes a common property. The exterior of all common parts of the building, right? Playing fields, recreational areas, driveways, car parks and parking areas, open spaces, landscape areas, walls and fences, and all other facilities and installations capable of being used or enjoyed in common by all the occupiers. So car parks and parking areas are also included. It is said, but it must be capable of being used or enjoyed in common by all the occupiers. If it is capable of being used or enjoyed by all or more than two persons, then it is deemed to be common property. Right? Now, I had a case, no, I wouldn't say it's a case. I had a referral from my client who was staying in a high rise place and there was water leaking. And he asked the management to come and repair the place. The management came and inspected and they said the leakage is your own problem. You'll have to do the repairs on your own. He was unhappy, complained to DBKL. DBKL sent their technicians who came and checked and said You will have to do the repair on your own. Now, that's when he consulted me. What I did was I got the contractor to come in, and the contractor identified that the crack is outside. Literally, the contractor put half his body out of the window to take photographs. We are more than 30 floors up. And then the contractor put in his report saying that this can only be repaired from outside, it's not from in. I then referred to the Strata Management Act. If you look at the fourth schedule at the back, the schedule talks about the duties and responsibilities, interfloor leakages, all these other things. And to reach this floor from the outside, you have to put a gondola right on top, and the gondola will have to pass at least 4 to 5 floors down to reach here to do the repairs. Once something is external, number one, and number two, it has to be reached by access through another unit. In all probability, it is a common area. It is no longer your unit. And so I submitted a further report to the DBKL, including all the laws. They came and did a second inspection, and then they agreed with me that it's common property, and they directed the MC to carry out the necessary repairs. So this is what actually transpired. So it can be a very touchy affair. It can be highly technical, and you have to sit and go through everything to find out what exactly is a common property, whose duty is it to repair it. The courts have even gone to the extent of saying right in the middle of the wall is your own, after the middle is common property, right? But especially your external wall. So this is the first difficulty we will have. You must look at the act that is relevant here, right? Uh, just give me 1 minute, please. I would like to request for 1 minute silence. See what I can do about the noise here. Sorry for that. I had to ask my staff to ask them to stop the knocking, right? So this is one of the challenges that we face. The second challenge that we face is that the definition given in the BCPA is not a complete definition, right? It is not a complete definition. It is quite inclusive, and then you get things like where more people can take part, where two or more persons, where everybody can enjoy, and that makes a definition. If you have the BCPA with you, look carefully, and you will see that the common property does not include things like the rooftop, for example. Is a rooftop common property? You see, because if the rooftop is common property, it cannot be sold to any individual purchasers. Then it has to be retained by the developer, handed over to the JMB, who will then hand it over to the MC. However, as many of you may be aware, there are many units where the rooftop is deemed to be accessory parcel. They have their own gardens right on top. So if that is the case, then the rooftop cannot be common property, but it is capable of being purchased by any purchaser, right? It becomes a common property. So that is another issue. The law doesn't actually decide what can and cannot be common property. Certain things are obvious. Certain things are very obvious, cannot be sold. Certain things are quite clear, it can be sold. Then we have the middle ground where all the disputes will start coming in. It was only much later that the law introduced the idea of a floor, the entire floor car park. This was with the arrival of mixed developments where you have malls and car park lots down. So the law introduced a different kind of strata property, entire floor car parks. So you cannot have half a floor car park, which belongs to the developer or anybody else, but you need to have the entire floor as a car park. Then one single strata title will be issued for this. Now, those are some of the disputes and challenges that we have. But there are also plenty of questions to be asked. But before I get into that, I want to advise that due to this great challenge and the failure of the court to be clear about what is common property, and because of the fact that common property has changed over a period of time, pre 1985, 1985 to 2007, then from 2007, when the BCPA came in, right until 2013 or 15, when the Strata Management Act comes in, and then the Strata Management Act takes effect from 2015 and also makes major changes to the Strata Titles Act. So we have different sequence of times. So you have to be very careful to check when was this building completed, under what law was this building completed. Now, of course, your second problem is the definition. What does it include? What does it not include? And so, because of this rather evasive situation, we are faced with a problem that you have to go to court in order to find out whether a particular part of the development is common property or not. And that is the biggest headache. Most purchasers do not want to go to court in order to find out. They want to know beforehand. They want to know beforehand whether this is common property or not. I'm sure the JMB or the MC likewise would not like to waste money from the maintenance fund to go and pursue these matters in court, because these can be rather expensive. These can drag on for a long time. Okay, I have several matters which are pending in the federal court, application for leave, and filed by MCJMB, and some are individuals. This is all very costly in terms of time, in terms of money. We would like to know beforehand, if possible. Unfortunately, when you talk about going to court, you will have to go and try it out and see, and then see how well you can convince the court, right? If the courts take the stand like JMC Klana, which I mentioned earlier, that although the case was decided in 2016, some 9 years after the introduction of the BCPA, yet the court said the development was completed prior to the BCPA, therefore the BCPA does not apply. It is wrong to try and retrospectively remove the rights. Interestingly, in JMC Klana, the Court of Appeal also said this, that titles have been issued to the developer, so the developer has indefeasible title under the National Land Code. And the federal constitution protects your property and your life. It says no one can be deprived of their life, no one can be deprived of their property without proper compensation, without proper justification. And the Court of Appeal used this to say, you cannot expect us to backdate the BCPA to enable property to be taken away from the developer, because that is to interfere with his constitutional rights. Right, that's where we are. Now let's jump to the BCPA and look at maybe a case which can help us along the way. And that case is the case of Malaysia Land Property Sendirian Berhad and Waldorf and Windsor JMB, decided in 2014. This was a case decided under the BCPA 2007. In this case, some of you may be familiar, one of the tower blocks, the 7th floor, was held back by the developer. He said that it belongs to him. It is an office section, and therefore they refused to hand it over to the JMB. The JMB challenged this in court, to which Several defenses were used by the developer. It'll be interesting for you to note some of these defenses. The first defense, the first, let's look at the arguments, how it goes. The JMB claims that the seventh floor is common property. Why? They claim that according to the sales brochure, the seventh floor was designated as the facilities floor. If it is the facilities floor, it would mean it should be the common facilities and should be handed over to the JMB. So this was their first argument. The second argument was there was no designation of an office floor in that particular tower. So that's their second argument. The third argument was that the developer had unilaterally converted that common property into a stratified property and had obtained strata title to that floor. And therefore, this is a fraud, and being a fraud, it will come under the exception to the indivisibility of title in section 340 subsection 2 of the National Land Code. To these, the developer has this to answer. The developer says, well, number one, the sales brochures do not form part of the sale and purchase agreement. Number two, they say, in your sales and purchase agreement and deed of mutual covenants, there is a provision that the developer may amend or may alter or make changes to the building plans. So this is already part of the agreement. The developer and the purchasers have signed this agreement. They have agreed to this. They have accepted this, and therefore they should be bound by it. So they put this there. Now, what is the court's approach to this? Okay, what is the court's approach? We look at the points that the courts have stated. I want you to take note of several things. Number one, the courts agreed with the JMB that according to the building plans, there is no provision for a commercial area. So the first clue is to determine common property, you can look at the building plans. Number two, right? The sales brochures show this floor as the facility floor. This means the courts accept the sales brochure as part of the evidence, not part of the SPA, but part of the evidence to determine whether this is common property or not. So to all developers out there, no use putting in your SPA that sales brochure do not form part of your SPA. Even though they do not form part of your SPA, they are still evidence that can be independently adduced in court to determine whether the particular property is common property or not. Okay. Number three, the court said that the developer, please take note, cannot use the provision in the SPA to make amendments to the building plan or to the strata roll after vacant possession has been delivered. I'll repeat that. The developer cannot use provisions in the SPA to redesignate an area, make changes or amendments after vacant possession has been delivered. Now the law provides, the latest laws of course provide that any amendment you need the consent, the unanimous consent of every purchaser for the developer to do it. Not just vacant possession. You need the unanimous consent of every single purchaser. Not at a JMB meeting, not at a meeting, but individually every person must give their consent. Okay. The next point that the court said was this, that a strata title was obtained by fraud by the developer, and therefore such a strata title is not indefeasible. The fraud was committed on the Pejabat Tanah in Galian. It was also committed on Jupum, that is a Juru Ukur, and therefore it is not indefeasible. Finally, the court also said, if indeed the seventh floor was a property or an asset of the developer, why did it not show up in the developer's accounts? It should have showed up in the developer's accounts or in the developer's books as stock in trade or as assets. So let's recap what the court is trying to say. The court is saying that in order to determine whether something is common property, apart from the act, the court will look at several things. Number one, the court will look at the sales brochures. Number two, the court will look at the building plans. Number three, the courts will also look at the assets, the stock in trade of the developer. If it is your property, why is it not appearing in your stock in trade? Wow, that's going quite outside your sale and purchase agreement. That's going all over the place to determine whether this is common property or not. But this is where the courts come from. And because the law is not very clear, the courts have to look at all these kind of things to determine whether something is common property or not. So there we are. There we are. There is the problem that we have. Now, let me go to the next step, right? Let me go to the next step. The next step that I want to go is, if you go to court, let's say you have all this in court, right? You tick, tick, tick and say, oh, yes, Mr. Patrick, I've got all these documents ready. I'm going to go to court and sue them, right? Do not be too sure that you're going to win. Why? Because you will have to name the Pejabat Tanah in Galian. If strata titles have been issued wrongly, you will have to name the council which gave approval to the building plans or which allowed amendments to the building plans, whether it's PJ City Council or DBKL, Majlis Perbandaran, right? You will have to get them. You will have to go and look for the approved building plans, the final building plans, when the building plans were amended. So to look for all these amendments. And if the council is unwilling to give because they are afraid of being exposed somewhere along the line, you will have to apply for discovery orders against the council and against the Pejabat Tanah dan Galian to obtain those documents. You have to get them, file your case in court, go for discovery, get these documents so that it will enable you to determine whether you have a case or not. Okay? We also have areas like difficult challenges. What happens if the developer goes and builds some extra building there, which is not part of the original plan? And the developer puts up an extra building and says, this is mine. Okay, this is your building plan. You got 4 blocks here, so you take your 4 blocks and you get lost from here. This is another separate block altogether, not part of it. This is mine. I will keep it. What happens then? You will have a lot of difficulties and challenges, right? We have had cases in the past. I wouldn't say cases. We have had situations in the past where developers have sold an entire block to one particular person. You may say, what's wrong with that? I think the first case that comes to mind is 32 Square. And it is a problem. Why? You cannot sell an entire block to one person. You cannot. Why not? As we saw in the BCPA and subsequent amendments to the Strata Titles Act, the block consists of three parts. It consists of the parcels which can be sold. It consists of accessory parcels which become part of your main parcel. It will consist of common property, the lifts, the staircase, corridors, toilets maybe, storerooms, electrical rooms, aircon rooms, all these. All these cannot be sold. All these cannot be sold. In 3-2 Square, was a very strange case. The developer occupied one entire block and the management did not maintain the place. So the developer is asking the management, you are supposed to maintain. The management said, you are the owner of the whole block. The court said, no, you cannot be the owner of the whole block. There are common areas there. Even though it's only one single owner using the place, still it's a common area and the management has to maintain the place and charge maintenance charges to the developer. So this is a problem. There are developers who have sold entire blocks. Sold, inverted commas, I use the word, because you cannot actually sell entire blocks. The only way out is a very complicated matter. Take that block out of your strata development. Destroy all the individual titles and make it one single title. This is what happens to many commercial buildings where it's one single title with many floors and then they just lease out as offices. One title only. That means the whole building belongs to that one person. That can be done. But you cannot have a stratified development having individual titles and individual accessories and then own the common property. You cannot own. It must go under the management. So this is the kind of situations that we are facing today. These are the kind of scenarios that we have today. Very complex matters. People doing things without understanding how it is done, right? And so the rest of us will have to face all the headaches. Okay, I think I will stop here. Thank you very much for listening to what I've said just now. Sorry again for the distraction from the sound. Thank you very much. Back to you, Naufal.
All right. Thank you so much, Mr. Patrick, for the insightful talk. We'll now move on to the Q&A segment where you will hopefully clarify any questions you have on today's topic.
Okay.
So first of all, we have a question from, I'm not sure if this is a question or a statement by Miss Kelly Lee. She said, there is no way to add accessory parcel in the title, right? When the developer has bankrupt. 90% of the owners have no accessory parcel.
Okay. Now, let me get this straight. Sometimes in certain developments, hopefully I can answer your question. In certain developments, there are no accessory parcels. Although there may be car parks available, but there will be no accessory parcels. In such cases, it is possible for the developer to sell individual parking lots or parking bays to purchasers. Where these individual parking bays are purchased by purchasers, they are then accessorized to the main parcel. So, in other words, the developer and the purchaser will have to make an application to the land office so that this parking bay will become an accessory parcel to be attached to that particular unit. If it is done that way, then it can be. So, this can be done. Now, otherwise, there is no law that says that you must have a car park. Now, compare this to a situation where, okay, because a lot of people are confused. When the uh, council issues the development order And if you check the development order, the council usually will provide that for every parcel there must be a car park allocated. An allocated car park is not an accessory car park. You will notice that if there's allocated, the developer or the management can change the car park bay from time to time. They just need to allocate to you. So the property is under the JMB, it becomes common property. It is not accessory, it is just allocated to you. For it to be sold to you, you have to buy it. If you buy it separately, you'll buy it in a supplementary agreement. You see, that can be done. Now, if the developer has an entire floor car park, he can't sell to you individual parking bays, because if he sells to you individual parking bays for you to accessorize, then he's no longer the owner of an entire floor. That will disturb and eat into his individual strata title. He can only lease it out to you. So these are the issues that we need to understand that exist. Now, if the developer is a bankrupt, the liquidator will take over. Then you will have to deal with the liquidator on this matter. Right? Okay.
All right, sir. I think there's a follow-up on this question by Miss Kelly. Uh, let me just follow real quick. Okay. Is there any way a management office can sell to owners who don't have accessory parcel? Developer has one.
Okay. Now, if the developer has gone into liquidation, right, then it is taken over by the insolvency, and there will be a liquidator who will be acting on behalf. So anything to do with the developer, you'll have to deal with the liquidator. Now, when you say management, I need to know who is the management here. If it is a JMB, the JMB have no right to dispose common property, and neither does the management corporation. They cannot. They can give you on a long lease, perhaps, but JMBs cannot, because JMBs cannot enter into contracts for more than 1 year. Only the MCs can do that. So your difficulty is if the liquidator is willing to sell a parking bay, and that is allowed, you have to look at the development order. If it is allowed, then you can accessorize it. No, you don't deal with the management on this point. You have to deal with the liquidator. Right? However, if it is already common property, then you cannot buy. Common property cannot be bought and sold, it can only be leased. Right? Okay.
All right. Thank you, sir. Moving on, we have a question from Mizadi. Are there any restrictions or regulations on how common property can be utilized or modified by individual unit owners?
Yes, there are. You see, the law provides that the management can rent out common property to individual owners. And some places it is done. For example, some developments may have shop lots downstairs. And these shop lots are common property. They're not individual titles. They're just common properties, some sections. And they can be leased out, right? If you have a chance to look at PJ Center Stage, for example, downstairs is supposed to be like, you have all these individual lots where the handphone companies can be there, handphone shop lots. So it can be leased out like that, right? So there can be arrangement to them, but you cannot modify the common property. They may allow you to utilize it and put up some temporary partitions, perhaps. So in turn for paying rental, that can be allowed. Yes.
Mm, all right. Thank you, sir. Moving on, we have another question from Ms. Nazliana Nazaruddin. How is ownership and maintenance responsibility typically allocated for common property among the unit owners or residents?
Well, you have to go back to how your share units are determined. So in the master title, there be a what we call aggregate share units, the total share units for all the units there. Then you take the common property. What are the expenses for the common property divided by the total number of share units times by the individual share units. So that is how you get it, right?
Mm. Thank you,
So
sir.
go back to your share units again.
Lastly, this will be our last question for today. How are disputes or disagreements regarding the use, maintenance, or changes to common property usually resolved within the development?
Now, unfortunately, if there's one thing lacking in uh, our strata laws, the one thing that is lacking is there is no internal dispute resolution methods. So, in
Mhm.
other words, the management does not have the power to call two conflicting owners to try to resolve it. They can do it informally, of course.
Right.
Legally, cannot be done. And
Mhm.
when you say there's a disagreement, it could be a disagreement between a developer and the JMB. It could be a disagreement between the JMB and an individual owner, right? Now, if it
Mhm.
is one of those, the only choice is to go to the tribunal to resolve this. Or if the matter is very serious, you have to go to the court. You see? So I've discussed this in one of my seminars, resolving disputes, I think under Excel Academy. I've done it
Mhm.
before.
Yep.
Dispute resolution, right, in
Yes.
stratified developments. So we have dealt with in length down there. You can call the COB as the first party. The COB can come and they can try to resolve it, especially if there are damage done to parcels or things like that. And then from there, it is a tribunal and the courts. That's the way it is resolved.
All right. Thank you, Mr. Patrick.
All
We
right.
have now reached the end. With that, I would like to invite all of you to our upcoming CPD seminars. So next up, we will have one on the 25th of August by Mr. Patrick Spashin himself on the topic of breach of contract, implications, consequences, and effective remedies. Uh, for there will be 9 to 5 in Armada Hotel Taranjaya for 5 CPD hours. Next would be in September. Um, we have one by Mr. KCT on a sales topic, uh, the masterclass in consultative selling and negotiation selling for property consultants on the 21st of September for 5 CPD hours as well. Then in that month, we have another seminar by Mr. Patrick himself on the same topic as the previous one due to high demand. Uh, on the 27th of September for 5 CP hours. And in October, we have one for a marketing topic by Miss Dini Tarjudin. It's on revolutionizing real estate marketing, unleashing the power of brand storytelling with artificial intelligence on the 12th of October. This one will be online for 3 hours. And lastly, another seminar by Mr. Patrick on the legal considerations of leasehold and freehold properties in the sales and purchase agreement on the 19th of October from 9 to 5 for 5 CPD hours as well. If you are interested in joining any of these seminars, you may contact our sales reps, any of our sales reps, as well as visit our official Facebook page, which is the Excel Academy of Real Estate Facebook page, and we will gladly assist you from there. Once again, I would like to thank Mr. Patrick for the talk today, uh, as well as all the participants, of course, for tuning in. We hope to see you in the next one. Thank you. Thank you, sir.
All right. Thank you. Thank you. Thank you, everyone, right, for joining in today. Hopefully, it was helpful. All right.